Good morning, everyone. Thank you for joining us for day 3 of Acquisition 104 Instruments. We have with us today Wayne Pace, who is the um, manager of the real estate section for acquisition, and we also have Greg Severance, who's the Associate Assistant Attorney General, and he advises ODOT concerning right-of-way functions that have to be completed in the course of our business. So you have 2 excellent presenters for today. Quick housekeeping items. Hopefully you have received the email last week that had the links to all of the handouts, but if you don't have those conveniently located at this point, you can look in the handout section of the GoToWebinar panel, and we do have what you will need for today loaded in there, including a copy of the slides. And then I noticed some folks have already started saying hi or hello in the question box. So if you don't mind dropping me a message in there just to make sure that we know that you know where that's at, so you can ask questions. And I know that our presenters will be stopping periodically this morning to ask for any questions that are in the question box. So I believe that's all I have, gentlemen. So it's all yours.
Okay, great. Thank you very much, Victoria. So we're going to have an interesting session today. And as we flip through this, we're going to take a look at the agenda. So our agenda today, we're going to have day 3 dealing with owners residing outside of Ohio, dealing with owners whose name has changed, dealing with name corrections, signature by Mark, and then dealing with Dower Interests. Greg will be talking about those topics. The next page, we're going to have dealing with individuals, minors and incompetents, dealing with life estates and land contracts, and dealing with the owner of an easement over a subject parcel. Greg will be talking about that. And then I will be reviewing over procedures of dealing with school boards when we're dealing with different types of acknowledgement forms. Remember earlier we talked about the special acknowledgement of the RE 249I. So we'll be dealing with examples of how school boards can be filled out, or municipalities or townships or counties. And sometimes you might have counties that has other officials to handle the um, initiating of the acknowledgement, charitable organizations, religious organizations, and fraternal order of organizations. So at this point in time, Greg, I am turning it over to you.
Great. Well, I'll see if there I am. I wanted to be sure to show everyone that I'm not a disembodied voice.
I'm glad to know that.
Yes, I do exist in corporal existence, as they say. So with that, I'll click myself off so I can see the full screen, and we can get started. This should be a fairly quick thing, I think, but we'll of course have it open for questions too. So Victoria will monitor those for us, but hopefully you'll have a better understanding of who needs to sign various instruments and stuff when we're done with this, and some of the procedures that go along with odd entities and such. In general, ODOT instruments obviously are used to acquire the property rights we need for the ODOT project. If any reason an owner residing outside of Ohio is unwilling to convey by an ODOT instrument, which is pre-approved, of course, by the Ohio Attorney General's office, then the negotiator, closing agent, has to contact their manager. The manager then contacts the transportation section of the Attorney General's office for guidance. And the reason we do that, it seems like an extra layer of bureaucracy or something, but it's because a lot of these questions have been answered before, and also we want to be sure that in a sense we get to view all the questions, that somebody in particular is the focal point to look at this and see if the same question keeps getting asked, then we know we have to change this particular program and our instructions and such. And so that's why we do that type of thing. We're trying to every day make it better. So next point is, if the difference can't be worked out with the property owner, ODOT may appropriate the rights needed for the highway project. And oftentimes that does happen for some reason or another. Somebody's unwilling or unable to sign the instrument, or sometimes we just can't find a particular party that needs to sign it. Well, then it goes to appropriation. And oftentimes that may be even considered a friendly appropriation, because one or more of the parties aren't really against it. It's just that there's got to be a way to get a clear title to the property. Whenever there's communication with any owner that's not face-to-face, ODOT must provide the explicit, easily understood written directions and instructions for executing the instrument. All right, a copy of the letter communicating such written directions and instructions must be kept in the acquisition file to document that ODOT provided adequate directions and instructions to the owner. Believe me, we get this all the time, that some owner claims that was never explained, or they weren't told or something. And something with that in the file, we know absolutely that that's not true. We always suspect it's not true, but we know for sure when the documentation's there. So let's see. All letters written in a professional manner that can be understood easily. Think of it as, it's often difficult for us, ourselves, to write something because we understand what it is we're trying to say. So always try to put yourself, in the position of who you're writing to, and what is it that they would be wondering or need to know. Okay, so now we're going to comply with ODOT's procedures for dealing with an owner or a grantor whose name has changed. This happens a lot. Okay, we deal with situations where the title report indicated a person or entity took title to the property in one name and now no longer uses the exact same name as he, she, or it did when taking title of the property. The example that we use first is 5 years ago, Alice Fremont, a single female, purchased 10 acres of real estate. 1 year ago, Alice married, and her name is now Alice Smith. Certainly not an unusual thing to happen. ODOT procedures require the person preparing the conveyance instrument to make clear that the person or entity signing the conveyance instrument, that's the grantor who would sign it, is the same person as the one identified on the title report. Some counties in Ohio require a grantor when transferring property to use the same name as he, she, or it did when they originally acquired title to the property. In those counties, a conveyance instrument that does not comply with the foregoing requirement will not be accepted for recording. That's getting a lot more relaxed than what it was, but it still exists, particularly in rural counties. The rule for the owner or grantor's name, ODOT's policy that all instruments conveying property to ODOT or acquired by ODOT for an LPA shall identify the owner or grantor by the same name that he, she, or it was known on the conveyance instrument by which he, she, or it acquired title. The name of the owner or grantor on a conveyance instrument or property acquired by ODOT shall be the same as the grantee on the conveyance instrument by which the grantor acquired title to the property. Now you get that? Obviously, that's the title change going back to the previous deed when the grantor to ODOT originally was the grantee of the property that we're talking about. If the owner or grantor currently uses a name that's different than the one by which he, she, or it acquired title, then the conveyance instrument to be prepared with the owner or grantor's name will be written as either name used when grantee, aka name currently used, or the name used when grantee, NKA, stands for now currently used. So you're looking at AKA, also known as, or NKA, now known as. now known as, the difference between the two is AKA is that often somebody's going by two different names. You know, they're Robert Smith, but everybody knows them as Bob Smith. So, and that's often how they sign their name, even though their legal signature may be Robert Smith or something. So that happens quite a bit. And sometimes people sign one document one way and another document another way. So they, in a sense, have two legal signatures. The now known as is more likely when somebody has actually gone through a legal name change, or used to be known as somebody all the time and then, you know, started maybe using their middle name when they actually became an adult, or later as an adult and started acquiring more property or whatever. Here's an example, the name change for marriage. Married was single, she bought the property. Now she's married and uses the name Mary. I would call that Smythe, not Smith. But the owner or grantor's name is to be written in the granting clause as follows: Mary Jones, now known as Mary Smith, married. Mary Smith was married when the property was purchased. She's now unmarried, okay, and uses the same name, Mary Jones. The owner grantor's name is to be written in the granting clause as follows: Mary Smythe, now known as Mary Jones, unmarried. So oftentimes a spouse may go back, particularly women will, since they're the ones that typically change their name, will go back to their maiden name. Or it's possible they, you know, again, could have gotten remarried in the meantime. Could have been a couple changes. You only need to worry about the latest change. A marriage may be terminated by death, divorce, or a number of instances, but that's basically how. When a person changes their name without formal legal proceeding, such as, there are instances when that happens. Okay. Change the spelling of their name. That actually happened to me. I had to get a new Social Security card because I did not know how to spell my own name. And Mom had never told me. It had never been that terribly important. So actually I had spelled my name several different ways. Not my last name, everybody knew that. But I never knew my middle name, how to spell that. And it turned out it's Scott, spelled with one T, not two. So always something different. Okay, so change the spelling of their name, or has added or deleted an initial. That happens a lot. Sometimes people drop the middle initial. Is presently going by a different name, and that happens. I don't know what would happen in the case of what, you know, remember Prince, where he was the artist formerly known as Prince and then substitute a symbol for his name. I'm not even sure how that worked for his contracts or whatever, but it must have, because he made certainly a lot of money while he was alive and performing. Let's see. The name of the owner or grantor in the granting clause shall be the same as the name of the owner or grantor as shown on the conveyance instrument by which the owner grantor acquired title. Remember the prior deed. Look at what that was and how they were known. His or her current marital status, followed by AKA, his or her name currently used by owner grantor. Again, also known as AKA. Example, the owner grantor is married and currently uses the name Willis Smythe. In the conveyance instrument by which he took the title to the property, his name appears as William Smith. Guess he decided to class it up a little. The owner grantor's name is to be written in the granting clause as follows: William Smith, AKA Willis Smythe, married. Owner's name changed by legal proceedings. William Smith has changed his name by legal proceeding to Willis Smythe. William Smith, NKA, now known as Willis Smythe, by legal change of name. Complying with ODOT's procedures for dealing with correction. As a general rule, there are to be no strikeouts, erasures, or handwritten insertions on any part of an ODOT instrument. If for any reason there has to be a minor correction on the instrument, then the correction must be initialed by the grantors, and the initial must be in the handwriting by the grantors. ODOT's real estate agent must acknowledge any correction by placing his or her initials next to the initials of the grantors. All right, complying with ODOT's procedure for signature by mark when a person, in other words, the person's unable to sign his or her name for whatever reason, possibly they're illiterate. Hopefully it's not because they're incompetent. So it should be because they basically can't read or write. Very rare, but it still exists. ODOT staff may assist that person to enable him or her to sign their name. If the person is unable to write, procedure will also allow him or her to sign by using an X. And it shows here an example, his mark, John X. Doe. Complying with ODOT's procedure when dealing with dower interest. Dower is an estate in real property that can be owned by only a married natural person. No artificial entity can have a dower interest. Corporations, partnerships, limited liability company, it's only for real people, spouses, typically a husband and wife. So there used to be something, this dates back from the Middle Ages, where in particular a woman was protected because everything basically belonged to the man, to the husband. So in order to protect the woman, she would have a dower interest in the husband's property, because that's the way things work. There was actually something at one point for the man as well called courtesy. That has since merged into dower. There is no courtesy. That was gotten rid of at the beginning of the 19th century, basically, in all English-speaking countries, and everything merged into dower. So now both a husband and a wife will have a dower interest in the other's property. Typically, you're only talking about the residential property, but it could extend to other things. It used to automatically. It's getting much, much more limited, and there's been a push in the legislature to do away with dower altogether, because it's kind of a holdover, like I said, from the Middle Ages. Women are working now. Many are holding title in their own name and such. So trying to track down perhaps a divorced or separated spouse who left for parts unknown makes it difficult to transfer property. And that's one of the reasons sometimes that ODOT has to appropriate property, because they felt it was necessary to get a disappearing spouse's signature on something, and that spouse couldn't be located. There was never divorce. The person just took off. ODOT's agents should make an effort to have the spouse of an owner sign the instrument. If the owner refuses to permit the spouse to sign the instrument, then a release of dower interest is not required. A spouse who's not named on any of the acquisition parcel's legal documents holds only an inchoate dower interest. And this inchoate right of dower only takes effect once the spouse having the valid ownership right is deceased. Inchoate is a legal term, again, ancient, that just means this, just exactly what the paragraph said. It kind of exists in the background. It's not really there. It's not effective or enforceable until essentially death occurs. So that's typically when it happens. It's not because of divorce, because divorce, all your property interests are figured out at that time by the court. So you're really talking about something that springs up upon death. And again, that's pretty rare. Most people, their property is taken care of one way or another, either by will or by deed. There might be a right of survivorship in the deed or something. So dower interest is kind of a holdover from the past, and it's largely frowned upon. If you really want to have an enforceable right in property, put your name on it. Put your name on the deed. That's the safest, best way to do it. Okay, so
Greg, we
next,
provided a handout on that too that gives them some extra information on the dower.
that's right. That's right. And what we're dealing with here, the reason I'm saying all this, we've researched this a couple times, originally back in the 90s, and then updated that again. I don't know, past, I don't know, maybe 5 years or so ago that we revisited this. And like I said, technically it's still on the books in Ohio that dower interest exists, but we look at it as kind of a risk management type thing. If we can't locate, you know, the spouse that's disappeared, then what's the risk? I mean, there's a bigger risk if it's a big piece of property, or let's say we're acquiring the entire marital residence, then that's a bigger risk. You know, that's something that somebody could come back for and claim perhaps some amount of money. There's a lot of problem with that though, because whoever claims the dower interest has to be able to show how much money they would be entitled to. In other words, what's the value of the property and what's the value of their interest? And remember, their interest only springs up upon the death of the spouse. So what's that interest in the future? How do you determine that? That's why dower is kind of falling by the wayside. It's a hard interest to quantify and put a value on it. Okay, so complying with ODOT's procedure when dealing with individuals. Oh, one last thing about dower, in a sense, why we're going through all these hoops with dower or whatever, that we're trying to make it as simple as possible for negotiators to get signatures on things. It used to be that if we couldn't get a dower release when it's a partial take and we're only acquiring a few feet of property, that was ridiculous, because our risk would be what? We have to pay $300 a second time, and somebody's going to come back on a dower interest and spend several $1,000s to get 300. Don't think so. So that's why it's a risk management concept. All right, our next thing, dealing with individuals. When the title report indicates that ownership is in the name of one natural person, not an entity, a natural person, that person's name is entered into the granting clause. And we have that in the Real Estate Manual 5402.01. The ORC section 5302.05, the marital status of any natural person signing an instrument must be inserted immediately after his/her name in the granting clause. Again, that relates back to the dower interest, but also may indicate that there's actually two people on the deed. Marital status used by ODOT, unmarried or married, individuals not married to one another, husband and wife for a married couple. All right, that there used to be something where you were a common law spouse. That no longer exists. I believe that was done away with in the 1980s, around 1985. Can't remember exactly when, but for a while you could, if you were living together and held yourself out as husband and wife, then that's what you were. But you had to hold that out to other people, and you might have signed, whether it was a hotel ledger or whatever, that you would say, yes, you know, Mr. and Mrs. Smith, husband and wife. Well, then you were basically married. That's no longer true. But because that was true for a period of time, it's possible, if you're dealing with pretty old people that held property for a long time together, you could still run across it, but it's very rare now. not likely to be seen. Okay, marital status not used by ODOT, single, unremarried widow, divorced and unremarried. We don't say that. Sometimes people take offense at stuff like that. Okay, next slide. The terms spouse or husband and wife are to be used only when a married couple owns property in both of their names. When the title report indicates that the ownership is in the name of more than one natural person, ODOT's agent preparing the instrument must determine the marital status of each owner who is a natural person. It's possible that you could have, two people own a piece of property together, what you call tenants in common, and each of them are married to somebody else. They're not married to each other. So that's a possibility. This may require the use of more than one acknowledgement form to be created. Complying with ODOT's procedure when dealing with a minor or incompetence. Any acquisition involving a minor or incompetent requires ODOT's manager of the acquisition process to contact the transportation section of the Ohio Attorney General's office. Again, go through the manager so that they can be, they can coordinate the questions, and they may know the answer already. All right. B, see Real Estate Manual, Section 54. Okay. Complying with ODOT's procedures when dealing with a life estate. Life estate is a person that has the right to use, occupy, possess, and enjoy the property during his/her lifetime, but does not own the fee title to the property. This often arises with older parents, particularly when there's only one, but it could be both, mom and dad that are, older. They want to continue to live in the house they've always lived in, but they want to go ahead and transfer the property to their children. That sometimes you'll see this done in a trust situation, but it used to be that it was always done as a life tenant situation, so that they would convey in fee simple all the rights to the property, all the ownership rights, except for the one where they could continue to live on the property until the end of their life. So that made them a life tenant. Life tenant, for our purposes, is required to execute a release of life estate form, which is RA 251. Again, life tenants you don't see as much anymore, like I said, because they're doing these things more in form of a trust now, where the older couple will hold it, the parents will hold it in a trust, but members of the trust or beneficiaries of the trust will be their children. Okay, see the release of life estate on the next slide, and there's an example of it. Complying with ODOT's procedures when dealing with a life estate. Remainderment, that's the person who owns the underlying fee ownership of the property subject to the life estate. Like I said, usually these are the children of the elderly couple. Upon the death of the life tenant, the remaindermen will own the fee interest of the property free and clear of the life estate. The marital status must be shown on the granting clause. The remaindermen will execute the conveyance instrument of the property, and the signature for the acknowledgement is RE 244. A lot of times people will do something like a life estate or the trust. Life estate is particularly good when you're talking about you don't want that asset to be figured in terms of maybe a nursing home contract or Medicare or whatever. We'll look back to see what are the assets of people that now need services, life-giving services or something that they can't afford. Well, this is a way for them to convey at least the house out of their names. So all they really have left is a life estate, which is very difficult to value because it's a gamble. How long is somebody going to live? So what's a life estate worth? Complying with ODOT's procedure when dealing with a land contract. Land contracts, there are quite a few of these. They're still around. It's a sale and purchase of land that does not require the seller to deliver the deed, basically the title, to the buyer until the buyer has completed making installment payments of the purchase price directly to the seller. The land contract is a way of selling property with the seller providing the buyer's financing without the use of a mortgage. In other words, you, the seller, the owner of the property, becomes, in a sense, the bank, because a lot of times that happens with buyers who cannot get credit. Let's see, or could be maybe a family member too, something where you just don't want to have them pay the interest that's needed on a loan. Common terms in a land contract: the seller is known as the vendor, the buyer is known as the vendee. Okay, the conveyance instrument. Land contract vendor signs the instrument. Land contract vendee signs the RE-241 release of part premise from lien of land contract. Prior to signing the conveyance instrument and release of part premise from lien of land contract, both parties must agree to the compensation paid by ODOT, because this will become a struggle. Who gets that payment and how's that payment figured? I mean, if I was the vendee, the buyer on the land contract, I'd want that payment to be included as part of my payment for the purchase overall. But maybe the vendor doesn't see it that way. So there are problems that come up with this that you may not be able to resolve as negotiator, in which case, once again, it may have to go to appropriation and be worked out with the Attorney General's office through the courts. Okay, next one. There's an example of the release of part of premises from lien of land contract. Okay, complying with ODOT's procedures when dealing with the owner of an easement over the subject parcel. Easement is a right to use part of the subject property by someone who is not the owner. There can be any number of easements, but often what you'll see is some sort of an easement that allows access, allows somebody to travel through that property to get to their property. Note easements in section 3C of the RE46 title report. That's where they'll show up. State whether the easement is in the take area. Identify it as permanent or temporary, or possibly a combination of both by the easement holder. RE-242 is to be used for partial release of the easement by the easement holder if take impacts use of the easement. I mean, it's possible, like we said, what if the take area is over on the far right-hand corner and this easement exists on the far left-hand corner? They're separate. The take has nothing to do with that. Though sometimes it's possible that some way it could impact it. You'd have to listen to what the landowner or the easement holder is saying as to whether they feel it's impacted. So identify the easement even if not impacted by the take, but make clear it is not impacted if you can. Like I said, it could be a question sometimes. I haven't run across that really. A good example of maybe how that works is power lines in rural areas often have what's called a floating easement, which means that they have the right to run the power line anywhere through the farm property. And just because it's at a particular place right now doesn't mean that when they decide that they need to change the alignment, they could do that. So technically, any take could affect that easement because it actually exists over the entire property. They're just using part of the property right now. Okay, call or email for clarification if unsure of impact. And that's true. That's if you can't figure it out, don't beat your head against the wall. Go to the manager. The manager hopefully has seen it before. If the manager has questioned, then that's what the Attorney General's office is for. Here again is a form, release of part of premises from easement. So we've tried to make these forms as simple as possible so that it's literally just plug in the names and information that you need. Complying with ODOT's procedures when dealing with the subject parcel that is in possession and occupation of a tenant. Tenant, which could be a renter, either commercial or residential, has a right of possession for part or all of the subject parcel and is considered an owner. Obviously, if it's like a single house and somebody's renting it, they have the right of possession of everything, of all the property. If it's, say, a strip mall or something, you know, which we run into quite a bit, that tenant has a right of possession to the particular storefront that they have, but may also have the right of possession to parking spots, part of the parking lot or whatever. And of course, is dependent upon access to and from that parking lot, which could be affected. Separate and distinct from other tenants, it's possible. All leases and tenants must be identified in Section 3B of the RE46 title report. Tenant rights are determined by the lease. Typically, the owner is entitled to the funds from an appropriation. It's called a condemnation clause typically, and typically it'll be near the end of the lease. The problem with commercial leases, residential leases generally get turned over. A lot of commercial leases, though, the company doesn't like to let those be seen. They don't want to have them see the light of day. And that's why, you know, most leases should be recorded at the recorder's office because it's an interest in land. But a lot of times all you'll see is a notation of a lease that one exists. And so you won't even see what the lease terms are. And so you'll have to ask the landlord, you know, what they are and for confirmation of that. A tenant usually has a right to a reduction of the rent from the landowner if the tenant's rights of possession are interfered with by the taking. Yeah, because his leasehold interest now is not as valuable as it was before the taking. Or in the case of a temporary easement by ODOT, he's, you know, his, like I said, his access may be interfered with for a certain period of time, hopefully not cut off completely. That typically doesn't happen, but it's possible that, you know, that he is impacted disproportionately by the project. Okay. If take requires tenant to vacate, tenant will be entitled to relocation benefits. And that's true, which will be moving expenses, not necessarily all of them or whatever, but there'll be, you know, a certain allotment for certain things. That's a specialty under ODOT. You'll need, the manager will have to deal with that because that's not typically, that's part of the appropriation. Call or email for clarification if unsure of impact. Okay.
Victoria, do we have any questions?
We do. We have a question that they would like to know who they would call or email for clarification if they're unsure of the impact of an easement.
Wayne, I'd say probably start with the manager.
Exactly. You will start with the manager that's of the acquisition, or the real estate manager with the department, and find out what the specific issue is. Sometimes that manager will be able to handle or answer the question, but if not, we'll automatically contact the Attorney Generals. And there are times that we will bring the Attorney General on with the realty specialist that's acquiring the property, because sometimes that realty specialist has additional information which is pertinent for the decision to be made by the Attorney General.
Yeah, good point, Wayne. That's exactly what I was going to say. I don't know how many calls I've been involved with where the manager and the realty specialist, just to name two, if not more people, sometimes we have to get the engineer involved too,
Exactly.
to figure out exactly what's happening on this particular piece of property, so we can talk with authority and knowledge to the landowner and assure them either there's no problem, or maybe the realty specialist through the owner discovered there was a problem that had been overlooked.
Right, exactly. Any other questions, Victoria?
Actually, there was an item in there from Laura Boyle, and I had asked her if she could clarify whether that was just a statement or if there was a question. So maybe she could put something additional in the question box, and then I'll just read that off the next time you stop.
Okay, great.
Okay.
All right, Greg, you are done for right now.
Yeah.
And now I'm going to take it over for the rest of the period here. This first section here is where we're going to talk about a few examples of special acknowledgements that when dealing with various types of entities, these are examples that we have assembled together, and they can be used. They're not saying that this is the actual way that it has to be done, but this is the best guidance that we want to give for the use of assembling some of the special acknowledgements. Please keep in mind that there might be times that you may have to contact us, and we'll contact the Attorney General in the event that you have something that is a little bit more unusual. But this does give a decent guide of information that would help you with your preparation of your acknowledgement form. And the first one that we're going to take a look at is dealing with school boards. And when you're dealing with school boards, school boards has to pass a resolution. And before the property can be conveyed to ODOT, one of the project management things that I always say that school boards do take time. They have various readings that you have to go through to be able, excuse me, to be able to get the board to pass it and get a resolution. So you have to plan your time accordingly. I always say to the students that are in my class, treat dealing with entities, particular entities, just like if you're acquiring a relocation parcel, because relocation parcels do take time, as well as the school boards, companies, that they take a lot of time and have their own processes that they have to go through to get these documents reviewed and signed. So in this case here, we're looking at it to where the name of the board is going to appear on the title report, and you're going to be looking at it as being into the granting clause of the instrument. They're going to use the RE249I. Here is just an example of what would go into an acknowledgement of the RE249I and witness whereof, naming the president or the secretary of the education of that school board, passing the resolution. If there's any other members, the president was signed, the secretary was signed, and then of course the acknowledgement and the notary notarizing the authenticity of the instrument. Now, dealing with a municipality, municipalities cannot convey the property unless the sale has been authorized by an ordinance prior to the signing. So they have to issue an ordinance that basically that authorizes the person to be able to sign it. So that authorizes the mayor, the clerk, to execute the document with regards of the instrument itself. Always get a copy of that ordinance that shows that they are the entity that will be signing the document. Once again, it appears upon the title of the title report and the granting clause using the RE249I. Looking at municipalities, once again, municipalities, their name is inserted into the acknowledgement form and the name of that signer and their authorized signer that is authorized to sign for that particular document. And so as you see the example that is shows here how we would put that together for the person that's in a municipality and how they would have to sign that particular document. Looking at when ODOT procedures dealing with townships, once again cannot convey the property unless they are authorized until they have a resolution. So their trustees are the ones that would generally sign and provide a resolution for signature. You always want to have a copy of the ordinance that shows that the resolution was passed, who was authorized to sign that particular acknowledgement as well, or in this case, acknowledgement merged with the conveyance document and exhibit is considered as the instrument signing the RE249I. And then where's the example here for that particular part, whereas the name of the signer, who's authorized signer, and then the name of the township. Okay, complying with ODOT's procedures when dealing with counties. Counties, once again, needs to have a resolution that would pass to the county commissioners, and that's prior to signing of the instrument. And then once again, we have to have a copy of the resolution. We need that for our file, of course, our acquisition file. Name of the county will appear on the title report. You're going to use the RE249I as well. Here is an example of the acknowledgement form for the RE249I when dealing with the counties. Once again, the county name and the name of the signator person that will be signing on behalf of the county, and then directly going into the portion of the acknowledgement form. Complying with ODOT's procedures when dealing with the counties and other officials. This was a little bit of the unique side here that one of our districts has been experiencing a couple of times. So we felt it was important to incorporate this slide into the presentation. And this is where counties, once again, cannot convey unless it's authorized by a resolution, but the county commissioners is designating an appropriate official to sign the instrument. So you have that situation, whereas a copy of the resolution is necessary, and we want to be sure that the county officials have in their resolution has passed the resolution for the property to be acquired, and a designated appropriate official will be signing. Here is an acknowledgement form that would show that, showing that it's the county and the name of the signature, who's authorized signer, and pursuant to the resolution by the majority of the Board of Commissioners, letting them know that the designated individual will be signing that particular document. Complying with procedures when dealing with religious or charitable organizations. It must be determined if a religious or charitable organization is unincorporated or incorporated as a procedure to fill out. The acknowledgement form is different depending upon the legal use, this legal use. Of course, there's our policy as under the 5402.09. And we're going to talk about briefly here unincorporated religious or charitable organizations. It's a little bit on the different side. In the event that we're dealing with a group of unincorporated groups, it cannot convey the property without the permission of the county, the Court of Common Pleas that's located where the property is located in that county. permission is to obtain obtained by petitioning and described in this transaction. This authorized the trustee or the officer to sign the conveyance. So they have to obtain permission from the court to be able to sign the document to convey the property. That takes time. Sometimes we have to go through the appropriation phase and work with the attorney generals to be able to get this accomplished. District offices will need to coordinate with the AGO, and that's with the attorney general's office. Now, when we're dealing with complying with procedures, when dealing with religious or charitable organizations that are incorporated, a little bit different. An incorporated religious or charitable organization can convey property in the same manner as a corporation. No need to obtain permission from the court because they're now incorporated. Preparation of the instrument, the name of the conveyance form goes into the granting clause according to the title report. Entering the status of the organization is incorporated or unincorporated after the name of the entity. In this case, we want to make sure it is incorporated. And the reason why you want to make sure that it's incorporated is because the organization that is unincorporated, you'll be using the RE249I that will be used. And you have to seek the Attorney General's for guidance. In this case, we're dealing with the RE that is a corporate, that is incorporated. So if it's incorporated, you're going to be treating it just like a corporation form, and you're going to use the RE247 form. And if you remember, we went through the examples of using the RE247 when you're dealing with a corporation. In this case here, the full name of the organization and the signature authority with regards to that organization. And I might add, one of the things that you have, of course, you'll have a signature resolution or the minutes when you're dealing with some of the charitable organizations as well, or you can provide them with the RE form for the signature resolution. So you have a few little choices there, but the main thing is the proof who is signing on behalf of the that organization. Complying with the procedures when dealing with fraternal organizations. Fraternal organizations or lodges usually empowered by the Constitution or bylaws to convey the real estate. A member votes by members present at a regular meeting held after the notice between and given all the members is usually all that is required. A copy of the minutes of the meeting authorizing the sale of the acquisition of the property. Of course, it's in our real estate manual. We're giving the section that is located in. Usually the presiding officer and the secretary will sign the instrument. And of course, it's according to the granting clause. And in this case, you'll use the RE249I. Here is the example of the dealing with the fraternal order. And do we have any additional questions, or do we want to go back to the one question that person needed clarification on earlier? Victoria?
We need to go back to that question because it was a question.
Okay.
They said sample letter of instructions available, RE non-face-to-face. So I kind of took that to mean, is there a sample letter of instructions available when you're dealing with non-face-to-face?
So are they saying it's, I guess I'm trying to figure out what that question is.
Yeah,
I think you're asking what if there's like a form letter that could be sent to somebody that you haven't been able to talk to, or certainly met face to face. Is there something?
Yeah, I went ahead and unmuted Laura Boyle on our end. Laura, if you want to unmute yourself, maybe you can just ask the question directly. she's not doing that, but she added in,
Okay.
yes, a form letter.
Okay. There's not a form letter we have, but those is one of the things that you want to craft a letter that's very simple and easy instructions for the property owner to use. Sometimes when you want to craft something like that, have another team member review that, make sure that they would understand it, but we do not have a specific form letter in our file for that.
Yeah, that's kind of an interesting point though, because it seems like ODOT has a form letter for almost everything. So
You got that right. You can bring
yeah.
it as a form.
So maybe that's not such a bad idea. That's
True.
maybe something to come up with, and something obviously it would be simple if it's a form letter, because you'd want to be able to put in the specifics of the situation or whatever, because every
Right.
situation is unique. So
Right.
that's probably why there's not really a form letter. But that other than that, again, it's trust yourself. Everybody here is literate. You guys are better writers than you think you are. And just think about, again, what would you want to see in a letter, and how would you want it laid out if it was sent to you, somebody was acquiring your property? What do you want to see? What are the questions that you would have? And again, sometimes it's very difficult to put yourself in the landowner's position when you've been doing this a number of years and all this stuff kind of comes automatic to you. So that's why I think Wayne's suggestion that someone else read the letter before you send it, just to make sure that you said everything that probably should be said, or that you didn't misstate something some way, or whatever, and just that it sounds good. That's it.
Right. Okay. Any other questions?
There are no other questions at this time.
Okay.
So it looks like we've come to the end. Is there anything else that you gentlemen would like to add?
No, we've completed it. And thank you very much for
Great.
everyone's participation. We have one more session to go.
Yes, absolutely. And that session is Thursday at 9 a.m. So if you get an email from GoToWebinar telling you that it's in the afternoon or some other time of the day, make sure you look to see what time zone it's put on there. I don't know why it's sent Greenwich Mean Time reminders to everybody recently, but it is 9 a.m. this Thursday.
Yeah.
Thank you,
Okay.
everyone. We'll see you then. Take care.